All right, this is case 06D349743. Counsel, if you can state your appearances, please.
And fine, bar number 25. Good afternoon, Your Honor. Present with my client, Christopher Horodesky.
Danielle Dawson, bar number 11792, on behalf of defendant, who's present.
Margaret Pickard, bar number 11855, here on behalf of Special Master Parenting Coordinator.
Okay.
I'm going to give you a chair.
We don't have any stipulations in this case.
No, pull up a chair, please.
All right. So, Ms. Dawson,
Yes.
I appreciate your appearance. Are you retained or are you appearing unbundled?
No.
Can you try and summarize for me, please, your client's opposition?
I can get it down to a couple points that
Okay.
we're looking for. The opposition and a lot of the pleadings that have been filed in this case, including some of the reports, are very lengthy due to the fact that it seems that we're continually rehashing the previous trial and things that happened prior to the trial in this matter. We would ask that essentially anything barred by McMonigal not be brought up in any pleadings going forward. I think that would limit the length of everyone's pleading and make it clearer to the court what we're requesting. Without going through the entire opposition.
Oh yeah, because that would take us a significant amount of time.
It
Well,
would.
most of it is McMonigal, pre-McMonigal.
Yeah,
So
yeah. I
she
get.
can just tell us
No.
what's happened
Miss
since.
Fine, thank you, Ms.
Sorry.
Dawson.
And basically what we're looking for right now is status quo pending a therapist's report. The therapist who they're currently using is an MFT.
Is this the child's therapist?
Yes,
or?
the child's therapist. There are significant issues alleged in the therapist's, I guess it was a report that was to the court. If it's that dire of a circumstance, I think we need a PhD or an MD treating this child. We would ask, because there's been a lot of allegations that it's plaintiff choosing the therapist, we would ask that the court simply give us 3 names and the order in which to call those people.
Well, if I'm not mistaken, this Ms. Steinkamp was she chosen by the parenting coordinator?
I chose Dr. Velasquez, but Dr. Velasquez chose Katie.
Okay.
Steinkamp.
So to the best of your knowledge, the plaintiff had no input in the selection of
No,
the.
I actually was the one who suggested Dr. Joe from the onset
Yeah.
because of the initial court order, and then subsequently when she closed her practice, she suggested Katie Steinkamp.
Okay. All right.
So when it transitioned, Dr. Velasquez was a doctor, obviously. So we would just ask that if there are such significant issues alleged, that the child be placed in the care of a MD or a PhD, someone who has a high level of training in this type of situation, and we would ask the court to put on record who they're recommending for that. As to custody, we're asking that things stay status quo. There was no indication in the therapist report why he is acting the way he's acting, what the cause of the behaviors are, and so we would ask that, and there was no assertion that taking Amber entirely out of the child's life would be in the best interests of the child. It was more of things are going on, we need to look into this further. And then as to the psych assessment that's requested, one was already done. It was a lengthy process. My client spent $5,000 having the psych assessment done on herself.
How long ago was that?
That was during the
Prior
trial,
to
so it was a year and a half ago about.
Okay.
Okay. 2 years ago.
May 30th.
And did Dr. Polini make any recommendations about your client's mental health at that time?
At that time, he stated that my client, without going into what happened at the last trial, she believed all the allegations that were being made. Did he say-
Psychosis.
Yeah, there was no, yeah, there was no issues with her psychosis.
There were no recommendations for her to seek treatment or engage in
Were you
counseling or
supposed to
therapy or
continue?
any other.
I don't have it, do I?
As far as I'm aware, no.
Is that your recollection, Ms. Fine?
I do not believe that, Judge, and I also would like to be heard on that, because I can tell you.
Anything else, Ms. Dawson?
As to the medical bills, there was a sort of agreement that the parties would offset that. We just asked that the agreement be honored. It was gonna be offset against the fees due to Dr. Joe. We have, an email stating that I got in this late, so I didn't get proof of that email, but I can always furnish it, after the hearing. And child support should stay status quo because custody should stay status quo if that is
Okay,
brief enough.
Ms. Fine.
One moment.
Yeah, I'm primarily interested in if you do in your file have a copy of that evaluation by Polini, or if you have it.
May I address that?
Yes, please.
Okay. I don't want to go back prima monocle, but I have no choice in order to tell you why Dr. Polini was instructed to do this. Dr. Polini was instructed to do a psychological evaluation of mom only. No input from dad other than wanting to know why he believed she was there, she was doing this. He didn't get to be a part of it. He didn't get to be tested. He didn't get anything. All Dr. Polini knew was that mom had to have a psychological evaluation. Mom had to have a psychological evaluation because mom kept insisting dad was a sexual molester.
No, I've got that. I just
Okay.
want to know if Polini made any recommendations.
Not only did he, I do not believe, I believe that he instructed them all to continue in counseling, but I don't have it, and Margaret is trying to find it. I can't, the file is 6 boxes. I can only tell you,
I'm
Judge,
with you.
that was not even admitted into evidence at the evidentiary hearing. So Dr. Polini testified, and the report was not admitted into evidence. I can tell you that there were many things Dr. Polini didn't know because it was self-reported. My concern is that she now wants a marriage, she wants everything to remain status quo while mom continued, I'm sorry.
Yeah, go ahead.
Well, mom continues to undermine the system. Mom spent months before we could get into Joe Velasquez. Mom spent months not signing a consent so that Katie Steinkamp could get involved. Mom has picked her own therapist who refused to work with my client. Mom refuses, and those were not PhDs or medical psychiatrists. The issue that I have, Your Honor, is that she chose people in the past that never looked to Chris for any input. The therapists think that mom has the problem, and she is causing the problems for the child. The child only has problems because when he's with his mother, she has some kind of hold over him, and he becomes zombie-like. Whatever my mother says do, I'll do. When the child is with Chris, the child's fine.
I've got that.
I'm sorry. I don't
Is there?
Um,
I mean, and I'm sorry to cut you off.
I know. what
Your paperwork was very well done. It was articulate. I was able to follow it. I know what your argument is. Now, mom's on the other hand. I mean, ma'am, don't file paperwork on your own anymore. Consult an attorney.
So,
You need to limit it to 30 pages plus the exhibits, but you need to limit it. I mean, I'm not going past 30 pages, and it was painful for us to try and wade through it. So I gave her attorney an opportunity to clean it up, but I'm pretty prepared to order at this point in time on a temporary basis. The court finds that there is a need in this case to modify the current custody and visitation schedule. That it is in the child's best interest at this time, on a temporary basis, that we award the father primary physical custody. I am going to maintain joint legal custody between the parties with the strict definition that joint legal custody entitles the defendant to obtain medical records and school records, that the day-to-day decisions will be made by the father. The court will require that any major decisions having an impact upon the child's health, education, and welfare should be communicated to mom, but at this point in time, those decisions will remain his sole purview. The court is going to is going to continue unsupervised visitation with mom, but is going to limit the amount of contact and the amount of exposure at this time. The court agrees that there needs to be a PhD involved in this case, but does not agree that that person needs to be involved with the child. The court will order that Ms. Steinkamp continue to provide the counseling therapy to the minor child. The court is going to instruct that mom obtain therapy with a PhD or a PsyD, somebody that has specific training. The court is not going to order an additional psychological assessment beyond what was previously done by Dr. Pellini. However, the court is going to offer mom the opportunity to obtain an assessment at her own expense to provide to the court to counter the statements that have been made by the therapist, by prior psychologists, etc. Is there, as for all these financial issues,
They're minimal, Judge. I mean, we have $1,000 that's owed to my client for a payment to Ms. Pickard because we weren't gonna get a report. We have $508, half of that, and half of $14 on medical issues. And someday we'd like to get that back, but that's not our priority. Our priority is Hayden.
okay. All right, do you have attachments? Did you attach receipts to your motion?
We did on the supplement. We left one out because we couldn't find it until
Okay,
this week.
on a supplement. All
I
right.
think they were checks, not
Uh,
receipts.
Yeah, if they're checks, just get something showing that they're a bank statement or something showing that they were cashed or that they were.
Absolutely, and I'll also provide you the one for when he swallowed the quarter and we had to take him and get that removed.
Does your client dispute that he had to pay the $1,000 to the parenting coordinator?
The issue with the parenting coordinator fees is that there's currently a fee dispute with the parenting coordinator. We would ask that that be resolved before the,
How
This
is
is what she does.
how is that
I think
being?
it's with the state bar.
Nevada State Bar arbitration.
That's true, Your Honor. There's been a bar complaint filed against me as a result of my actions in this case, also against Ms. Fine, also against Dr. Joe Velasquez. Dr. Ponzo was also threatened with a complaint, which is what's happening in this case. In fact, I had told the parties I intended to withdraw
Receipts are
because of non-payment. So that's when this report came in from Dr. Katie Steinkamp, and I followed through with this. But at some point, I am going to have to withdraw as a result of non-payment. And I understand that's part of the PC process, but I would
Right.
appreciate any input from the court if possible.
Okay, the $1,000. The $1,000 will be awarded to Dad if there's a recovery or a mitigation through the litigation process. The court would address that at that time. These are temporary orders. In order to make permanent orders, it's my belief that I would have to conduct an evidentiary hearing, Ms. Fine, unless you have some other basis, and so my inclination is to set the matter for an evidentiary hearing to address the change in custody. How much time, how far out would you be seeking that I set trial?
Just don't set it between July 10th and July 22nd.
Oh, no problem. If you're ready to go in August, then
I'm ready to go yesterday. I know this case almost so well that I don't have to prepare,
Well,
but
I
the
mean-
receipts are here, Judge, the receipts
no,
are here.
I know, but we're talking about the change of custody is what
Right.
I'm talking
I know,
about.
I'm talking, but I just wanted you to know. the
And you know, the last order, substantive order, was June of last year, and so you know that's our McMonagle date. There has to be some change in the circumstances since then, and I think the non-compliance issues that we have give me cause to conduct the evidentiary hearing. Does
Yeah.
August provide you enough time, counsel, to?
If my client's doing a psychological assessment, it's
Well,
August is
And
going to be
that's what I'm saying, is
Tuesday.
I'm not ordering it.
Yes.
If she's able to go and see somebody, I think this gives her enough time to at least disclose who she's seeing and name him as a witness. I know that the rules required we provide expert reports, 90 days in advance or something? And Ms. Fine won't need 90 days, I don't think. We can probably minimize that. But I'm going to set you a date in August. If issues do come up, we can continue that, we can push that. But I'll try and go towards the end of August if that's...
I would like it to be before school starts, because I've got to keep, one of the biggest problems is school.
At this point in time, you know, with the way I'm defining the legal custody and the primary physical custody, I don't think that the school's really going to be an issue. The child will be zoned. Where does the child
Gibbons.
been
He's at
attending?
Gibbons. He's been at Gibbons.
And is that in Dad's zone?
Well, it's where Dad's, it's,
Is the answer.
nobody lives in that zone, but it's the school that he's been going to for the last 3 years, and he has stability.
And your client wants to keep him there?
Yes.
All right. So we'll allow him to maintain the child. Does your client have an objection to that school?
She does, but we understand that the child is going to stay at Gibbons for this next year.
Okay. If they will accept the child,
Yes.
then we'll allow, well, don't say yes,
No,
because
they've already granted the variance.
I know,
and
their
unless-
rules change all the time, though. If the child's accepted, then we'll allow Dad to determine that'll be the child's zone at this point in time. So give me a date, the latter end of August, 26.
9 a.m.?
It's gonna be all day.
We're scheduling it for 3 hours.
My concern is, in the interim, Judge, I would like to know if you're going to modify the schedule at all.
I am. I'm gonna modify the minimum, which day? 25th?
25th would be for a full day.
We're gonna go August 25th. We're gonna schedule it for 6 hours, commencing at 9 a.m. 3 hours each side. Okay?
I do have questions about the therapy, but I think Ms. Fine had.
I'm happy to work with you in any way I possibly can.
Okay.
I'll
My
provide you
question
with
is, what is the, you ordered that my client see a therapist, a doctor. What is the goal of that therapy, I guess?
Well, I'll tell you what. You pick that therapist and provide them with a copy of Steinkamp's report and Polini's report, and if they can't figure out what the goal is and need further guidance from the court, I'll provide it to them at that time. The goal is to assess mom's parenting abilities, weaknesses, to address any shortcomings and issues, to allow her an outlet for frustrations with the court situation, attempt to assist her in working through those issues without involving the minor child, appropriate parenting responses. I mean, I can go on, but I think it'll be very clear and very evident what the goal of the therapy is. I mean, the goal of the therapy is to put mom in a position and teach her coping mechanisms to where the child's welfare comes first, and that she can distinguish between her interests and the child's welfare.
Instead of always making it everybody else's fault, She needs to understand.
No, I thought I was fairly
I know.
clear about that.
But I was just simplifying it. I just want,
We specify that all reports in this case will be disclosed to the therapist,
Yes.
including Dr. Ponzo, all open arms reports.
Yeah.
Dr. Joe reports.
Yeah.
Because the last therapist didn't have that. And just for clarification, Dr. Paglini's report does indicate that mom does need psychotherapy.
Okay.
And so I think it's just important that we specify
Well, yeah.
all records.
All records, all reports, and we'll go from there. And I know it's putting you on a very short time constraint, and I'm not sure how prepared you are going to be. I'm conscious of that. If she does wind up with an expert that she intends to have testify, and you need additional time, I would be more than happy to consider that. But the reality is it's a disservice not to try and expedite this a little bit, and your client is going to be her contact is going to be quite restricted until such time.
Will it be subject to makeup time if it comes back and there is no issue?
Sure. Sure.
And I will make
I'll
the offer.
consider it.
I will make the offer right now that if council would like to contact my office and come over to my office, I will be happy to provide her, as long as she signs a receipt of it,
Yeah.
the receipt, all the reports, all of them, and to go over them with her.
All right. So, Ms. Dawson, your client's currently working?
No, she is not.
And sir, what are your days in your schedule?
I work pretty much as
What is your
needed.
schedule?
I go in
please?
every day, but 2, 3, 4 hours. I can work around when Hayden's at school.
All right. So I want to do. Is mom able to pick the child up from school at all?
Yes, that's the part we're concerned about.
Would it be appropriate to have her pick the child up for school for a few hours? Or is there an issue?
She goes onto the campus, she
Well,
harasses.
I'm
Oh, you're
trying to-
asking Ms.
trying-
Pickard.
trying to get some input from Ms. Pickard about the best way to effectuate some time here.
The time for mom?
Yeah, would it be appropriate to have her pick up the child from school, or?
Yes, I think, well, basically the schedule is such that Katie Steinkamp indicated the mothers to have visitation week 1, Thursday at 3 o'clock, which would be the release of school.
That's not what he's doing. He asked you if there was a problem picking him up at school.
There isn't, but school's only in for 5 more weeks.
No, you're right, sorry.
So, I think, based on whatever schedule that you provide, it would be an appropriate third-party location, which I designated last summer. We used the child's.
Did Ms. Steinkamp actually suggest a schedule? I'm
Yes, she did.
not sure I saw that.
She wanted it to stay the same, basically, which I don't agree with, and I'm gonna ask you not to do that.
Yeah, okay. So, look, I'm gonna give mom each week, you want Saturday or Sunday, ma'am? Sunday? So mom will have each Sunday from, we'll go from 10 a.m. to 8 p.m. And then we'll have Tuesday,
Well, he's not in school, it could be longer.
yeah, we'll go from Tuesday, from after school for the next few weeks while the child is still in school, from Tuesday after school until Wednesday drop off. And if once school is out, then we'll have from Tuesday at 3 until Wednesday at 3.
We have receiving parent pickup,
Yeah.
and it's not at school.
And, Your Honor, just for the order, the basis for the change in custody is the therapist report, or?
It's a culmination of this therapist report, Ms. Pickard's report, the allegations that mom continues to put the child in the middle. There's clear evidence that she's coaching the child and attempting to alienate the child's affections. The court finds that there's a deleterious effect and the child's welfare is being materially and substantially compromised by her actions and her behavior, by her alleged actions and behavior, but to such a point that in an abundance of caution this court is required to limit the contact that she has. Now, ma'am, this is a temporary order. We're going to have a trial in August, but this order can be modified, and it can be modified against your favor. If the child continues to exhibit these symptoms and continues to have these recurring issues, and the court finds that it's because of the way that you interact with the child, the court could further limit your contact with the child. Do you understand that?
Yes.
Yep. So August 26th, 9 a.m.,
August 25th.
25th.
Let's go.
August 25th, 9 a.m. Each side will have 3 hours. We're going to give you a scheduling order. 1 week prior, that'd be August 18th, we'll require written pretrial memorandums by each party. Those pretrial memorandums should include specific written orders that you wish the court to address, and it's very helpful, and it would be very much appreciated if you would include specific proposed findings that you believe your evidence will support. Also, on or before the 18th, any evidentiary objections to the opponent's proposed documents and or exhibits must be exchanged between counsel and your originals provided to the court clerk. Those documents must be exchanged no later than August 11th. Your proposed documents exhibits all need to be bound, tabbed, and independently page numbered or date stamped. All the volumes the same so that we can quickly find the information being solicited at the time of trial. The cutoff for discovery will be August 4th. And can we get witness lists by the end of June?
Yep.
Okay, so we'll ask for witness lists by, actually, how about June 23rd?
I'll tell you right now.
Same date for expert disclosures?
Yeah, well, disclose the expert witness. Like I say, I understand the timeline. You can't comply with that 90, I think it's a 90-day requirement on those.
I will be happy if she finds someone on July 25th. Let me know.
Yeah, if, like I say, if you're able to get an expert report, I'm not sure that Ms. Fine's going to want to go out and hire a separate expert, but,
No.
just let us know, but whoever she does choose, and I'm not saying she can't hire a separate expert from who she chooses to do her ordered therapy. She probably ought to if she's going to go that route, but the therapist needs to have access to all the reports. And if she intends to call an expert, the expert would be the court would require that the expert review all the prior reports from psychologists and mental health professionals,
Absolutely.
therapists, MFTs, etc. Anything else, Ms. Fine, that we need to address today? Child support.
Child support was ordered, but because I know she's gonna have all these expenses with the therapist, I'm interested in her pursuing that. I would like to hold on to not order child support so that she can utilize any funds that she would
Okay.
be spending on that. But I want the court to know that if in fact child support is ever ordered, I want a figure imputed to her of what she could earn because she's an accountant and she's capable of earning a substantial living.
But so he's currently paying her support?
No,
No.
nobody's paying anybody. Should be paying him, but
Okay.
we didn't enforce it.
All right. And so
that
anything else, counsel, that needs to be addressed at this time?
Just a clarification on whether it's being waived or stayed.
I am not asking for child support as long as she does.
Waived at this time.
If she doesn't comply with your
Yeah.
orders, then I want it.
The court's going to reserve jurisdiction to retroactively modify the child support based if mom's non-compliant.
Understood.
Anything else?
Your Honor, there is a fee dispute that has been filed with the bar, but it doesn't indicate that it's gonna go forward. Assuming it doesn't go forward, if I get a positive, or a dismissal from the state bar, can I get an order for some type of monthly payment that's due from mom for my services? Because I have been providing them for over a year with no payment from mom.
I think there's already an order that she has to reimburse 1,000.
Yeah, that's to
That's just
dad,
for what's been
but
paid.
she owes you money.
She's had no payment since, I think it was January of 2013.
How much does she owe you?
Yeah.
4,500 and something.
Yeah, if the once the fee dispute is resolved, the court would consider. I mean, if there's she needs to pay you, or, you know, she'll lose the services, and if she loses the services due to non-payment, I mean, it could be a legitimate and a significant issue at the time of trial. Okay?
Thank you, Your Honor.
All right, so, ma'am, you need to see what you can do to come and make some arrangements to make payments.
And attorney's fees I would like deferred as well.
Yeah, the court will defer attorney's fees as well,
We'll submit a financial disclosure form for the evidence.
and you'll prepare an order for today.
I will indeed. And I will have Ms. Lawson sign off,
All right,
unless she doesn't agree.
Thank you, Your Honor.
okay,
And it's a pleasure to have counsel on the other side.
yes. And Ms. Dawson, if you could approach on an unrelated matter,
Yes.
you can come up